Thank you very much. I now invite the delegate from the EU Cyber Direct.
Merci, Monsieur le Président.
Thank you very much, Chair. I'm speaking as a representative of academia researching international law on cyberspace at a strategic research centre for the military school and a rapporteur on international law on the EU Cyber Direct project. International law is one of the central topics of the work of our open-ended working group and the group of governmental experts. The applicability of international law was confirmed and affirmed by the two previous GGEs, and there's no question about it today. However, the application of international legal norms and principles of international law remains a topic of controversy or even disagreement between states. Questions on the applicability of international law and the application of the norms and principles of international law are two sides of the same coin. Thinking about this question leads us to question how the norms and principles of international law should be applied and on their content and limits. It's one of the direct consequences of the flexibility of international law, which is one of its specific aspects. On the basis of these observations, the main question is how to strike a balance between what should be agreed by states on international level and what should be left to unilateral interpretation of each state. The third question links to the two main challenges that are brought by the applicability of international law in cyberspace. Firstly, given the unique characteristics of cyberspace, given on the interpretation application of norms and principles of international law and how they apply to cyber operations, could depend on the level of operation but not on the level of transformation. Secondly, topics of international law, particularly states, could have different interpretations or diverging interpretations of some specific norms of international law. And this is my main point. Like in other fields, the unilateral interpretation by states has an important role to play, and this must not be underestimated, particularly in international procedures. With this in mind, more and more states are publicly expressing their approaches to international law, and this was recommended by the resolution that created the GGE. But we need more states who are not participating in the GGE to express their point of view on this issue. And this was recalled by previous speakers as well. This is a particularly important point which could also be considered within the open-ended working group. And this would then foster the participation of states who are not participating in the GGE of their views on international law, but it's also an important point for capacity building. It allows us to identify the needs for legal and strategic cooperation. I think that all of these aspects must not be underestimated. International discussions on the application of international law in cyberspace, alongside discussions on the content itself of these norms. Universities have published works over the last couple of decades on this topic, and this gives different perspectives and points of view on this question. Finally, we would like to highlight that the previous observations are particularly reflected in the current debate on the need or whether is there a need to address this, as was reflected in the previous statement. The adoption of a newly legally binding instrument could be justified in the future through the identification of specific problems which cannot be solved by existing law. However, in addition to other than identifying legal gaps, we also need to determine if we should also have new international legal norms adopted through non-binding agreements, for example, the codes of conduct, or indeed leave this to the interpretation of each state. Currently, the current legal void hasn't yet been identified that would need the creation of such an instrument, because the majority of states haven't expressed their unilateral interpretation of international law in cyberspace. Thank you very much, Chair.
Thank you very much. Speaking in particular on the need for a wider conversation, including states who have not participated in the UNGGE before. I also wish to acknowledge that Singapore herself has not participated in any of the previous UNGGEs. This is our first time that we will be participating next week. So I fully agree, and that comment resonates with us. And also to expand that conversation to wider non-governmental organizations, multi-stakeholder, as we have today. I now call on a delegate from IPEN-DETEC